When you look at a catastrophic risk, like a massive offshore oil rig fire, it is easy to assume that the business owners are safely walled off from the legal fallout. There is a persistent myth in business that incorporating a company grants the founders absolute, impenetrable immunity. In 2008, 3,000 gallons of gasoline leaked from an underground storage tank in California. The corporate officers involved hired a professional consultant to manage the cleanup and handle the environmental agency. They assumed their corporate structure insulated their personal bank accounts from the disaster. They were wrong. Look at this slide summarizing the court's decision. The judge applied the responsible corporate officer doctrine, holding the executives liable with the corporation. At the bottom is the fatal blow, a civil penalty of $2.5 million levied directly on the officers. The Department of Justice formalized this exact approach with the Yates Memo, instructing federal prosecutors to actively pursue individual accountability. Under the participation theory of tort liability, if an executive personally directs or participates in wrongful conduct, their corporate title offers zero protection. The corporate shield is a legal construct, not a physical barrier. When an executive crosses the line into participating in a tort, creditors and prosecutors can shatter that shield, reaching right through the company to seize personal assets, homes, and savings. To understand how to protect those assets, you have to understand what a C-Corporation actually is. It is a separate legal entity, a fictitious person created by the state. When an entrepreneur incorporates, they execute a legal severance, splitting their commercial risk away from their private life. If you operate as a sole proprietorship or a general partnership, your personal assets remain fully exposed to business debts. A C-Corporation legally limits a shareholder's liability specifically to the exact dollar amount they invested into the business. Advanced corporate architects maximize this protection by utilizing a dual entity structure. They create a holding company to secure valuable intellectual property and cash reserves. Below that, they create a distinct operating company to hire employees, sign contracts, and absorb daily operational risks. Isolating liability like this encourages entrepreneurs to innovate and makes passive investment possible, but it also introduces a severe moral hazard. The people reaping the financial rewards are legally walled off from the everyday physical and operational hazards of the workplace. Building a shield that actually holds up in court requires rigorous adherence to state law.
This video contains affiliate links. I have a relationship with the brands in this video and earn a referral fee when you shop through the links in the description below. Before we break down exactly when to upgrade your corporate structure, let's talk about your foundation. While a basic LLC is great for starting out, it has serious limitations if you want to scale. If you plan to raise venture capital, issue stock options to attract elite talent, or reinvest your profits back into the company without paying personal income tax on them, you absolutely need a C-Corporation. Most founders stick with a standard pass-through structure for too long, and that is exactly why they miss out on major institutional funding. To unlock venture backing and maximum corporate tax flexibility, your business needs a formal corporate framework. That's where Busy comes in. Busy is the absolute best formation service out there, handling your entire C-Corp setup for just $0 plus state fees. They take care of all the heavy legal lifting, filing your articles of incorporation, managing your required registered agent service, securing your EIN, and handling compliance alerts so your corporation stays in perfect standing. If you are building an empire designed for massive scale, this structure is non-negotiable. I've linked my full Busy review in the description. Use my link down below to register your C-Corp today and unlock exclusive discounts and perks. Get your corporate foundation handled first.
Delaware is the premier jurisdiction for this, and constructing a Delaware C-Corporation requires following a strict 9-step mechanical blueprint. First, the founder must select an unregistered name containing a formal designation like Inc. to publicly signal the entity's limited liability. Next, they appoint a registered agent with a physical street address in the state, and finally, they file the formal articles of incorporation with the Secretary of State. With the foundation laid, the company needs an internal rulebook. Founders draft corporate bylaws to dictate meeting protocols and administrative rules, and then appoint an initial board of directors to oversee high-level strategic management. To finish the structure, the board authorizes the issuance of stock certificates to shareholders in exchange for capital. Then, they file Form SS4 with the IRS to obtain an employer identification number, effectively generating a social security number for the new corporate person. If a founder skips a single one of these procedural steps, they introduce a structural flaw into the entity. In the event of a lawsuit, creditors will find that crack, and they will exploit it. Look at this legal research guide covering Delaware and Georgia corporate law. It outlines a mechanism known as piercing the corporate veil. When owners abuse the corporate form, courts will disregard the company entirely, bypassing the shield to impose debts directly on the shareholders. The most common trigger for veil piercing is commingling. If a founder uses the corporate checking account to pay for personal groceries or a family vacation, a judge will view the business as a sham, a mere alter ego of the owner. Another fatal trap is undercapitalization. Launching a business without enough funds to cover foreseeable liabilities or basic operating expenses proves to the court that the company was never a distinct, self-sustaining entity to begin with. To defend against this, founders proactively embed exculpation clauses into their corporate charters. Under Section 102(b)(7) of Delaware law, this specific provision limits the personal liability of a director to the corporation for monetary damages involving breaches of the duty of care. The liability shield is not a passive right that exists just because you filed some paperwork. It is a conditional privilege, maintained only through daily, rigorous administrative discipline. This structural rigidity is exactly why venture capitalists demand the C-Corporation format. It allows the company to issue different classes of stock with varying voting rights, making it the premier vehicle for raising massive amounts of capital and scaling operations. But with that scale comes a non-delegable duty. Directors and officers remain personally liable for compliance failures if they do not establish robust systems to detect and correct regulatory violations early on. The highest courts in the country treat corporate oversight as a strict fiduciary responsibility. Ignoring obvious warning signs of financial misconduct or safety issues is a direct breach of a director's duty to the company. In highly regulated sectors, the standard is even harsher. Under the Park Doctrine, agencies like the FDA can impose strict vicarious criminal liability on corporate executives who fail to catch health and safety violations, regardless of whether those executives personally knew about the infractions. The C-Corporation offers unmatched asset protection and equity potential, but it demands complex administrative upkeep and subjects the business's profits to double taxation. The idea of total executive immunity is a myth. The corporate owner, the public-facing individual, must rigidly respect the internal administrative boundaries of the business entity to remain protected. Corporate leaders hold immense power, but that power isolates them inside a structure of personal risk. They alone carry the burden of maintaining the machinery of the company.